Hello, good afternoon, everybody. My name is Karen Tereposky, and I am an employment lawyer from the Calgary office of Safiro Tumarkin LLP. I am with you today to answer your questions about employment law, and hopefully we have some interesting conversations today and some good topics to discuss. Before we get started, I don't have any questions kind of lighting up my inbox yet. I'm sure there'll be some soon, but before we get started, we can kind of chat a bit about some of the topics that have been in the news. One of them that I've seen is there's some return to work mandates coming in, and those have been kind of a hot topic in the last year or so, where employees were allowed to work from home, working remotely, and then they are being returned to work, mandated back to work by their employers. And a lot of employees are asking, like, can my employer legally do that? The law kind of is that employers do have the right to determine where you work. So unless it has actually become a term of your employment contract that you work from home, and that's a little bit of nuance to that as to when we can determine whether it's a material term of your employment contract and whether they can change that term. If it hasn't, if it was sort of meant to be temporary, the understanding is that employers can make you come back to work. So, if that happens to you, I think it's worthwhile having it reviewed by a lawyer to see whether we can make the argument that that's become a material term of your employment, and maybe it's a constructive dismissal if that's being changed unilaterally. So. Okay, I see I do have a question that's popped up here from Eva on Reddit. Recently quit my cashier job at a grocery store. When I went to pick up my final paycheck, my manager said I won't get it until I return my uniform and clean out my locker. I've likely lost the uniform. Can they legally withhold my pay for this? Do I have to pay for the uniform? What should I do? So employers usually can make some holdbacks to your pay for things like that, but there has to have been a term of the employment that's allowed, because under the Employment Standards Code, it has to be in writing that you've authorized your employer to withhold amounts. Often when you start a job, they'll make you sign something that says that they can do that. They can't withhold your whole paycheck, though. That's something that that's money you've earned. They may be able to make a set off for some money that you owe them for a lost uniform or something like that. So probably, as far as what you should do, if you think you've lost it and they're saying they're not releasing it until you return it, I guess you could go to employment standards, make a complaint, and see where that goes. But it might be better first to just talk to your employer and say, listen, I've lost the uniform. What are you going to charge me for it? And can you just take it out of my final pay? And if you can't work that out amicably with your former employer, then you may have to resort to going to employment standards and having them take that on for you. Okay, next question from Blaze on YouTube. I work outside doing landscaping as a contractor. My company changed recently, but I kept my job. The new company requires us to wear black pants and blue t-shirts. I've told both the CEO and my supervisor that black pants are unsafe in the extreme heat, but they insisted I still wear them. My supervisor even said I'd be fired if I refused. With temperatures hitting over 40 degrees with humidity, I've worn the pants so far, but I want to know if I can switch to cooler pants without risking my job. So an employee does have the right to refuse unsafe work. Whether or not that would rise to the level of unsafe work is probably debatable. Black pants of what kind? Are they a specific kind? Like, are they making you wear, corduroy or something that's really hot in the heat? Or can you wear something black that's breathable? There could also be in landscaping a safety component to wanting you to have your legs covered. So, obviously that may be a safety concern. The color of the pants, it may be a little bit difficult to argue that there's a safety concern that's worth an OH&S complaint over black pants versus blue pants. But at the end of the day, an employee does have the right to refuse unsafe work, and if an employer insists on that, it is an occupational health and safety issue. So if you were fired because you refused unsafe work, you may have the potential to go to occupational health and safety and make a complaint for, I think it's called unjust dismissal or wrongful. It's not wrongful. There's a complaint anyway under occupational health and safety. I can't remember the exact terminology, but it would be dependent on the determination that wearing black pants is an unsafe work condition. And I can't guarantee that OH&S would come up with, a determination that the color of your pants constitutes enough to refuse work as unsafe. So I would be careful with that. You may have recourse, but you may, be subject to somebody's determination. It's a subjective determination of whether that really is unsafe work. So, hopefully that answers your question. I have another one from Mitch, looks like from YouTube. I had to request a leave from my workplace to help to take care of my father. My employer said, if I go, then don't come back. I worked there 5 years, very upset by this. Am I owed anything? So if you're in Alberta, which I'm in Alberta, so we usually talk about Alberta employment law, there is a job protected provision under Alberta employment standards for, caring for family. It's generally terminally ill or it's compassionate care leave. So it depends sort of how sick your father is, but you may qualify for that leave. And if you do, it's, a certain number of weeks of leave that they cannot fire you for, else it's a violation of the Employment Standards Code. So there's the possibility there. There's also a possibility that could be a human rights violation as a family status discrimination, because, if you are required to take care of family and, you're being fired on that basis, that may be discrimination based on family status. So there's, some recourse there potentially. If they fire you for doing that, I would look into the leave under employment standards. You can, Google it. It's compassionate care leave, I believe it's called. Or obviously, if you want to, if you do get fired and you want to do a severance review for that, obviously you can reach out to us at Zamfiro Tumarkin and have one of our experienced employment lawyers review your file. They can determine whether or not you're owed anything or what you're owed, and then help you get it. If you are dismissed on that basis, I think that you potentially would have a claim for some severance or possibly human rights damages as well. Next question on Reddit from George. My spouse was recently terminated after nearly 7 years with her employer, just 3 months after returning from maternity leave. The company cited restructuring and offered 4 months pay plus 1 extra week if she waives her right to any legal claims, giving her 7 days to decide. We're wondering if this severance offer is fair and whether the timing raises any legal concerns. Any advice would be greatly appreciated. It's the fact that they've waited a few months from maternity leave. I think you would need something more to be able to argue that it has something to do with maternity leave. If there were some comments made, or if there was the impression that they were unsatisfied that she went on leave, there's some evidence that this is connected to the maternity leave, then there's potentially a human rights element to it. I don't think it being 3 months after returning is enough to make that argument. So I think there would have to be more on the human rights side. As far as just the severance payment, 4 months pay plus 1 extra week for a 7-year employee. So there's a lot of factors that factor into how much severance a person is owed. Just years of service isn't the only one. There's also consideration of age, the level of the position, whether it's managerial, supervisory, if it's sort of a specialized position. Availability of similar employment is another one that has to be considered. So I don't think I have enough information to know if that severance offer is fair. Always able to reach out to our firm to get a severance package looked at. You come through our intake, they'll give you a good idea of whether or not they see it as something that if they see it as something that they're going to pass on to a lawyer, then, likely there's something to it. There's likely a claim there. And then obviously once you talk to the lawyer, you're going to find out, what the assessment is. But, I would recommend reaching out. Initially, we do generally do free consultations, or at least that free intake piece where, you get a baseline idea of whether your offer is fair is going to help you to know. Next question from YouTube. How do you go about dealing with workplace harassment if it's coming from a manager? Yeah, that can be difficult when it's your manager and that's the person that you're supposed to be reporting these things to. So a lot of organizations do have a harassment sort of org chart as to how you report, and it should sort of think about it. It should have contemplated that this could be the situation. So if there's something like that where it says, you report to your manager, or there should be another option, you might want to look into that to see if there's something on your intranet or something that sort of gives you another out if you don't want to go to your manager. Sometimes there's also like a anonymous line to call in some organizations, depending on the size of the organization you're working for. One thing I would recommend, though, is to document everything, because if you do need to come talk to a lawyer at some point, then, you have that documentation of what you're considering harassment, and, dates and times and things that were said and everything, because that's important. If you are alleging harassment, you need to be able to establish what it is, and those facts are going to be important rather than just saying I'm being harassed. You have to be able to say, on July 29th at 2 p.m. this is what happened, and these were the words that were used. So write everything down. And if you can't, if you're really struggling to find someone in your organization that you can report to, come talk to a lawyer, and we can look at your situation and try to help you out with that. Next one from Reddit, from Rocco. My previous contract job ended a few months ago, and I've since started a new full-time position elsewhere. Recently, I received a formal non-renewal letter from my former employer that includes minor complaints and vague language like breach of trust. I'm wondering if this could have any future consequences, or if it's just a formality I can ignore. Okay, so contract ended, you've moved on. I mean, if the letter is just from your employer, at this stage, it doesn't sound like they're pursuing an action against you. If you get something from a lawyer, that might be more worrisome. I feel like I would have to see what this letter says to really understand, whether or not it's something that you need to push back on. Usually if it's just from your employer, though, I mean, they haven't escalated it to whether you're getting a letter from a lawyer, they haven't escalated it to, they're suing you. So at this stage, it's probably nothing to, that you can really action, unless you want to get more legal advice on it and get someone to actually review that letter. But, just from what the facts that are in this message, it doesn't sound like anything yet, subject to not sort of knowing all the facts. Like I said, if you do get something from a lawyer, then obviously you need to action it. Okay, from Ali on YouTube. Does working for a US-based company as a Canadian mean you have different rules, holidays, etc.? So if you're Canadian and you are living in Alberta, you are subject to Alberta employment standards. If the company is based in Texas or California or whatever, you are not subject to Texas law or California standards. You are subject to the standards in the jurisdiction where you are doing the work. So if you're working remotely from Alberta for a Texas company, or even if you're working on site but the company is based in the US, you are still subject to Alberta employment standards. Sometimes in your employment contracts, they will say the contract is governed by the laws of the state of Texas or something like that. You may be able to have the contract governed by that law if you agree to it, but the actual employment standards minimums, you're an Alberta citizen, you're subject to Alberta law. YouTube from James. I keep getting paid on different days of the week. Oh, I don't know if I can't see the end of this question. Can I go down a bit more? There we go. I keep getting paid on different days of the week. Bi-weekly usually was just Fridays, but recently Mondays, Tuesdays, and even Wednesdays with no word. Why is this allowed? That's strange. I don't know what's going on there. Have you checked with the employer? Maybe they're having an issue with their payroll provider. Usually, you should know when you're getting paid. And if there's any change to it, you should be informed. So if they haven't said anything, I would reach out to the company and find out what's going on. Like I said, it might be they're just having an issue with their payroll provider. Sometimes, you get into a situation where the company's having trouble with cash flow and they're having trouble paying. So that could be a concern. And if that's a concern, you be careful about how much work you do without getting paid. Yeah, I mean, again, employment standards might have some answers for you if you want to reach out to somebody there on making a complaint about paydays not being reported, and they may want to look into your employer. So that may be a place to go for that. I have a question on Facebook from Kindly. I recently applied for a teaching job at a private language center in Ontario. The manager invited me to interview, but said most clients prefer female teachers, so there wouldn't be many hours for me. I'm a man, and that was the only reason given. I feel this could be discriminatory and inappropriate. Am I overreacting, or is this worth filing a complaint over? Could this realistically lead to a finding of fault? So, I mean, sexual discrimination should go both ways, or gender-based discrimination. It's not just based on like a minority issue. It's just gender. So, really under human rights law, something like that would be gender discrimination. When it is in a teaching position, or not a teaching position, when it's in a position that you're applying for, as opposed to you already being in the position and losing your job on that basis, you have to be able to show that you would have got the position but for the discrimination to get damages, right? So, I mean, it sounds like that's actually what they told you, but, would it lead to a finding of fault? It's possible, depending on the evidence, depending on, what credibility determinations are made. Obviously, you're going to say this is what they said, and they may not agree with that story. They may say, oh, we didn't say that. And then a tribunal would have to look at who's credible. It could be a tough fight because it's just based on probably your word against theirs in a verbal setting, unless, there's notes or recordings or that kind of thing. So, I would say it probably is prima facie discriminatory, but, would it lead to a finding of fault? This is a hard one to answer because, it's probably going to be based largely on credibility. If you're found to be credible, if they believe what you say, there may be. And is there damages? Well, if it's determined that you would have got the job but for the discrimination, then you could be entitled to damages for loss of that job or loss of getting that job. Another question from YouTube. In your experience, is it common for companies to give without cause employees the silent treatment when negotiating separation agreements, then to extend that silence into the demand letters? I mean, sometimes when I talk to clients, when I talk to our leads that come in that are not yet clients, but they're having us look at their severance packages and deciding whether or not to take us on or to retain us as lawyers, what I say to them is there's three possible responses we get for a demand letter. The first one is, we disagree with everything you say. They always disagree with everything I say, but here's an offer. The second one is, we disagree with everything you say, but we're offering the same amount again, or we're still not offering anything, go away, take it or leave it. And then the third option that we sometimes get is they just ignore us. So, I mean, basically what I tell people is if we get option 2 or 3, or if, we can't negotiate that first option to where you're willing to accept it, we have to sue them. Sometimes employers will just ignore you and hope you go away and hope you're not serious and hope that you're not actually going to sue them. But sometimes as soon as they get a filed court document, suddenly they're all ears and they want to communicate because they want to settle it. So, I don't think it's, the norm, but it does happen sometimes. And when you sue them, they can't ignore that anymore. So that's the next step. Next question from Ali. Oh, that's not a question. She's just saying thank you. If that's the case, then if we have to work Canadian holidays, would they need to pay us holiday pay? They should. You're subject to Alberta Employment Standards. You're subject to Alberta Employment Standards Code. So yeah, they should be paying you holiday pay based on Alberta holidays. This is a long one from on Reddit, from Biker on Reddit. Sorry about my dog walking around in the background. She likes to make an appearance. I'm a clinician with a regional health authority, and I recently started a side business to provide diagnostic testing locally, something our field currently outsources due to limited domestic capacity. I disclosed the business to my employer, assuming they might support the idea, but it triggered a lengthy conflict of interest investigation, even though I have no decision-making power over lab contracts, budgets, or referrals. Now management is asking to see my full business plan, despite the fact that the company is still in early development with no clients or revenue. I've been transparent throughout, but this request feels excessive. Are there legal limits on what kind of information my employer can demand in a case like this? If you're subject to a conflict of interest policy, generally, in order to set up any sort of business, especially if you have a sort of time and attention clause in your employment agreement, where you're supposed to give all your time and attention to your employer, and there's also a conflict of interest provision or a policy, usually you have to get approval beforehand. So in order to get approval, sometimes they ask for details. And if you want the approval, you have to provide the details. So if you don't want the approval, then you don't have to provide the details. So, legal limits on what kind of information they can demand. Really, are they demanding or are they requesting it? Because if you want to get the approval from your employer to be able to do this and still keep your job, then you're going to have to provide them with what they're asking for. If you don't want to get that approval, then that's another decision. What can they demand? They can't make you give them anything. It's more of a request in my view. But ultimately, at the end of the day, you have to be careful, because if they determine that it is a conflict of interest, you could be fired for cause for breaching conflict of interest policy, or they could just terminate you without cause, and pay you a statutory minimum. So, you're 1 or 2 weeks or 4 weeks or whatever under employment standards. And then they'll say, well, you're setting up this business, so you've already got another business. You don't have any further damages. So I think at the end of the day, it's more of a practical question than, a legal question on what they can demand, because I don't know that they're demanding. I think they're requesting. And you obviously can say, well, no, I'm not providing that. But if you don't get the approval to, run this other business, then, you're risking your first job, which, are you okay with that, I guess, is the question. I don't know what that question means. Okay. Just have a few more here and we run out of time, so let's do it quick. Bill from YouTube says, I work as a contractor for a local plant. There's been a lot of talk about staff getting trimmed due to work shortage. What rights do we have as contract workers? Well, first thing you have to consider is, are you really a contract worker? Because sometimes you're called a contract worker, but you're actually an employee. Or even if you are a contract worker, you might be a dependent contractor. Dependent contractors are entitled to severance just like employees. So employees, the way that the courts look at, are you an employer, are you a contractor legally, not just in name, is, whose business is it? Are you in business for yourself, or are you in business for that employer? Some people are referred to as contractors, but really they don't have a business of their own. They're maybe getting paid through a corporation. They're really an employee. So, if you may actually be an employee, and then you have the same rights as an employee, even though you're called a contractor. If you are actually a contractor, so you are in business for yourself, but you're a dependent contractor, and the test for that is that you're dependent or a high degree of dependence on this employer, whatever person that you're working for. There's a degree of permanence of the relationship, and there's also some exclusivity. So you're really only working for one person, or maybe one other one on the side, but you're earning most of your income from this person. So if you meet those tests, if you're an employer or dependent contractor, you're entitled to severance. If you're truly an independent contractor, you're not entitled to severance. If you are a contractor, there may be some terms in your contract that deal with your entitlements on termination too. So check that. As far as how much severance, obviously, the way to try to figure that out, I guess, is you can look at our Pocket Employment Lawyer, which we have online, where you put in your factors and everything, and it'll tell you how much severance you could possibly be owed. Am I allowed to record conversations or interactions with this manager if I need to? I have to be careful about surreptitious recordings of our employer. There has been some cases where employees have been terminated for cause, and the courts have upheld that as cause for termination when you're secretly recording conversations with your employer. So, you may be able to say, well, I'm recording this, but I think if you're secretly doing it, you may be very careful about that. I would say that that's pretty risky, because if you're found to have been recording things, they could say that's a breach of trust, and that could be cause for termination. I've been reading about severance. It looks like employers are required to give severance. I'm wondering, what if the employer just doesn't pay and drags the process? Are there legal consequences? I mean, severance, so your severance entitlements under the Employment Standards Code, so your statutory minimums. So, it's if you're 90 days to 2 years, you're entitled to 1 week, 2 to 4 years, 2 weeks, 4 to 6 years, 4 weeks, 6 to 8 years, 5 weeks, 8 to 10 years, 6 weeks, and 10 plus years, 8 weeks termination pay. Those are statutory minimums. They have to pay those. Those have to be paid within 30 days of the end of the pay period in which the termination occurred. That has to be done quickly, within, like a month or 6 weeks kind of thing. Common law severance, which is the amounts above that, so those are just minimums. There's really no timeline on when that has to be paid. It can be paid way down the road if we've sued, and we might get to a trial 3 years after termination, and that's when it's paid. So there's no requirement on that. They should be paying it as soon as reasonably possible, but if you're negotiating with them, sometimes it does take longer. And dragging the process, that's kind of what employers do in a lot of cases. So there's not really legal consequences for negotiating or using, the legal process to defend a claim of severance. So hopefully that answers your question there. I think I've dealt with all the questions that we have, there was the percentage of, what is the percentage to ignore, from a guy on YouTube, but I'm not sure what that refers to. Oh, okay. That was the question about companies ignoring the demand letters. What percentage ignore? I would say it's a pretty low percentage, not very many. A lot of times when demand letters get ignored, it's in a situation where it's just cause for, say, like a breach of a drug test or something like that, failing a drug test. Sometimes they'll ignore those because they just think they're right. Or sometimes where they think they have an exemption. I get those in construction cases a lot, where the employer thinks they don't have to pay because they're a construction employer, but that's not necessarily the case. There's no termination pay owed under Employment Standards Code for construction employees, but under the common law, they have entitlements. So, but I have had quite a few construction employers that just ignore the demand letters. So I don't know if I could give you a percentage. I would say it's pretty low, maybe 5%, but it does happen. So I think I've addressed everything. I hope I've answered everybody's questions. And obviously, if you have more questions after what I've tried to do in the short time that we've had today, reach out to us at Samphira Tamarkin, and we can talk more about your matter and hopefully resolve it and get you what you're entitled to. Join in for our next session, which I think is coming up tomorrow. Thank you a lot for joining today. Tomorrow, 1 o'clock, with Lior, one of our founding partners, and our founding partner on the employment side, Lior Samphira. So that's tomorrow, 1 o'clock Eastern time, if you want to join in and listen to his employment law Q&A. Thanks again for joining us, and everybody have a good rest of your day.